Senator Kombowe Friday Benson, representing Bayelsa Central Senatorial District. Mr. President, sometime on the 10th of May 2016, while addressing an audience, the Prime Minister of the United Kingdom made a very open declaration about Nigeria and Nigerians. That Nigerians are fantastically corrupt, distinguishing nobody, excluding nobody. The statement was so clear that Nigerians and Afghanistan, these two countries are the most corrupt countries in the whole world. And here we are. Sir, I want our very distinguished acting Chief Justice of the Federation to help us to explain those who David Cameron were actually referring to. Are they here? Which of them are the corrupt Nigerians? Are the senators corrupt? Is the judiciary corrupt? Which of them, which of the Nigerians is David Cameron referring to? Mr. President, sir, are we expecting a corruption-free moment and period of our reign in Nigeria? That is my question, sir.
Requirements of being a Chief Justice of Nigeria is to possess the power of witchcraft. To be able to interpret what a Prime Minister of United Kingdom meant with his statement. If you ask her now to explain what David Cameron meant, it means you are expecting her to possess some kind of spiritual powers that are different from her legal about her competence and her experience in legal matters, not in fact, this brings me, my Lord, you can take the stage and join it and answer this other one. Should judicial officers allow social media reports to influence their decisions? Because you see sometimes in court, some people may take like 1,000, 2,000 people to bombard, and even right now, when I was a young lawyer and I appeared before you in 1989 in the Magistrate Court in Lagos, at that time, whenever there was a case in court, nobody was expected to comment on it. But today you see very celebrated senior advocates of Nigeria sitting down on television to comment on cases that are already before either the Court of Appeal or before the Supreme Court, in an attempt to influence the outcome of those cases. And then sometimes they sponsor social media rats to go attacking the judiciary and trying to influence in one way or the other decisions that are already before the courts. And sometimes they are even the counsels to those cases. So what will you do to stop judges from bothering themselves about the opinions of people on social media, about comments by prime ministers in other countries who themselves are not clean, about Nigeria? And then you focus on the law. You focus on decided cases. you focus on your conscience and things that will promote the rule of law in Nigeria, and ignore the outcry of sponsored social media. How will you make sure that their lordships across board ignore those things, bringing injustice to Nigerians because of social media publications? My Lord, and then you may choose to ignore the
Distinguished Senator Ekong Samson, Akpabio South. I will address the issue of the need for substantial justice and whether there must be compliance with laid down the issue of substantial justice and technicalities. Over the years, we have emphasized in our judgments about the need for courts to promote substantial justice over technicalities. However, I believe that sometimes there's a misconception on what constitutes technicalities. Because we have rules, we have laws, we have precedents that we follow. And where a precedent is followed, it will not be correct to say that the court has enthroned technicality over substantial justice. All courts are admonished all the time to eschew technicalities, but it's not in every instance that matters are decided on technicalities. At the same time, where the court looks at the case before it and decides based on the facts and the application of the law. Sometimes the application of the law to the facts might appear to be rather technical, and this is why we also have the appellate courts who can correct errors where they are made. On the issue of elevation to the Supreme Court, I will crave your indulgence to leave that question for a different forum. Distinguished Senator Adams Oshomole from Edo North. You talked about the crowded courts docket and the position where at a point in time matters terminated at the Court of Appeal, later on moved to the Supreme Court, and then the difference between cases filed at the Federal High Court and cases filed at the State High Courts. What I would say is that it is the legislature that enacts the laws that confer jurisdiction on the courts, and therefore anybody who has an option to go to either the Federal High Court or the State High Court is entitled to utilize that option. At the same time, where cases are decided, where it appears that a certain side is favored, the appellate procedure is there. And I think that is the only way we can curb it, unless there is clear evidence of bias or any inducement, corruption, or anything like that. But other than that, whatever decisions are given, the option is to go on appeal. And if you can satisfy the appellate court or the Supreme Court that the court concerned was swayed by other considerations, then the court will give whatever judgment is applicable in the circumstances. Now, on the appointment of new judges, the situation where judges have been recommended for appointment and they have not been sworn in that instance, the National Judicial Council has made its position very clear, and it is the National Judicial Council that gives the directive for who should be appointed. And once that is done, there is nothing more for the National Judicial Council to do. It is to the detriment of any state concerned if it is now working with a lower number of judges, and you have capable and already confirmed judges that are not being able to carry out their duties. It is not a matter that the Supreme Court can intervene in unless a matter is brought to the Supreme Court on that issue. The issue of compensation for a person who has served his time and found to be not guilty, can the Supreme Court order compensation? The Supreme Court can only decide on matters that are specifically brought before it and grant reliefs. And where there is no legislation that gives the court that power or that authority, there's nothing the court can do. At best, the court can just make an obiter comment on it, that this is a situation where, in ordinary course of things, this person ought to be compensated. But it's not for the Supreme Court to unilaterally make such an order, because everything we do has to be based on the jurisdiction that is conferred on the court. Distinguished Senator Abdul Ningi from Bauchi Central, you asked for assurances with regard to ex parte orders and an issue of ex parte orders prepared in advance, whether the hands of the judiciary is tied, and whether there should be legislation against the grant of ex parte orders. Now, the situation with ex parte orders, where it is, you see, in order to have the judiciary that we desire, we also need to be able to follow through on certain issues. If there's a situation where a judge is found to have ex parte orders prepared in advance, such a judge should be reported to the NJC and necessary action will be taken. It is not fair, even on the judiciary, when these allegations are made and nothing is done to substantiate them or to follow up on them. And we know that even when petitions are filed before the NJC, in some instances, you find that the petitioner comes back and withdraws the petition. So it is important for the NJC to be able to exercise its own powers, that these sort of matters are brought to its attention. And then the grant of ex parte order is discretionary, but there are guidelines. So where a judge is found to have ignored those guidelines, to have acted without due regard to proper process or even the facts of the matter, then the necessary action will be taken once it is brought to the attention of the National Judicial Council. As I've mentioned, the code of conduct will be strictly enforced, and judges are admonished not to grant ex parte orders indiscriminately. So it's an act of misconduct. But at the same time, it would not be proper, in my humble opinion, to enact a law that does away entirely with ex parte orders, because they are necessary in certain circumstances. Distinguished Senator Ofowe from Bayelsa Central. Pardon? Hombowe, I beg your pardon. I want to believe that his question was rhetorical, and I have, I think, the permission of His Excellency to pass it over about whether who are those corrupt people. Then, Your Excellency, your question: should judicial officers allow social media to influence their decisions? Certainly not. We have taken an oath of office to carry out our responsibilities without fear of favor, affection, or ill will. So whatever is in social media definitely should not affect the way we make our decisions. However, it is true that there is a lot that goes on social media and other fora. And this is one of the aspects that gives the contributes to the negative perception of the judiciary, because you have narratives out there that have no correlation to the facts that are before a particular court. And again, whether they are senior members of the bar or other members of the bar, there are procedures. A senior member of the bar who has earned the rank of silk, it's a privilege. It's not a right, and that privilege could be withdrawn if it is abused. So in any of these situations, the courts too will use their own powers. We do have powers where a matter is sub judice and somebody goes out in public on the television station, media, social media, to comment on those cases, because it does have a negative effect on the administration of justice, on how we handle our cases. Because when you then give a judgment, the way it is assessed is based on what has been in social media. But notwithstanding that, I would say that judges know the oath they have taken and will abide by that oath and not be influenced by social media. Thank you.
My Lord, you were very political in the last